Nearly 6 months after murdering 3 girls at a dance class in Southport, Axel Rudakubana will face sentencing today. The trial was set to begin this week, but Rudakubana unexpectedly entered guilty pleas to all charges, including murder, attempted murder and terror-related offences. Following this, the government announced a public inquiry into the missed opportunities to stop the attack. Daw KC is a barrister, legal commentator and author of the book Justice on Trial and joins us this morning. Hi there, Chris.
Good morning.
Good morning. Right, just set out then what we can expect to happen in court today then.
Well, the process is straightforward in terms of the sequence of events. So the prosecutor will outline the facts of the case in some detail to the judge and obviously thereby to the public. And then the defence barrister will mitigate the sentence to the extent that that's possible on the facts available. And then the judge will pass sentence and he will set out in some detail the facts of the case once again and the legal milestones that he has to kind of consider as part of the sentencing process. And then in the end, he will announce the minimum amount of time that the defendant will spend in custody before he can apply for parole.
So obviously we were expecting this to go to trial, so we were expecting to find out a lot more information about what's happened and the background to it. But now that it's not going through a full trial, will we hear much more evidence today, or will it be much of the same as what we already know?
Well, you will hear a fair amount of detail. The prosecutor, because there hasn't been a trial, the process involves the prosecutor giving a lot more information at this stage to the court than would be the case after a trial, where obviously all of the evidence would have been heard in front of a jury. So the prosecutor will set out the key elements of the prosecution case, the evidence that was discovered, and the process leading up to the eventual guilty pleas. So the public will hear a fair amount of detail, and it may well be that after the sentence hearing that further information is released into the public domain by the Crown Prosecution Service in terms of detail, video evidence and exhibits and the like. So all of that will still come into the public domain. It will just come into the public domain rather more quickly today than it would have done if the case had gone on for trial for many months.
Obviously, there's been a lot of discussion regarding his age, the age of which he was when he committed these crimes, but also as well his age now. What sort of sentence is he likely to face, considering his age?
Well, he will inevitably face custody for life because that's a mandatory sentence for any murder conviction. The only question for the judge that has any real bearing on the eventual date of his release is the minimum number of years that he must serve before he's eligible to apply for parole, and that's called the tariff. And the judge has to set that figure, and that figure is, as I say, is the absolute minimum that he will have to serve, not the maximum.
Okay. And in terms of when you change your guilty plea or your non-guilty plea, and the fact that he did decide to plead guilty, unexpectedly it must be said, but will the judge consider that? Will that change anything? Will that reduce his sentence in any way?
Yes, it may reduce the overall minimum term slightly. The guilty plea came on the day of trial, so the sentencing guidelines suggest that the maximum discount, as we call it, from what the sentence would have been after trial should be 10%. There are circumstances in which the judge can say, well, no credit is required or no discount because of the circumstances of the case. But you are talking about 10% of a very, very large number of years. So, for example, if the judge had in mind a minimum term of 50 years, it might be reduced to 45 years. So that's the sort of difference that the guilty plea may make, but the judge may choose to give him no discount whatsoever. That would be surprising because obviously the courts want to incentivise people to plead guilty.
Yeah. The trial was set to begin this week with him entering a guilty pleas to all charges. Obviously that's not happening, but you've been involved in many, many trials. For the family, for the friends of the victims, and people who are not involved in any way but have been watching, what can it be like for the family or for those involved when the person responsible changes their plea at that last minute and therefore they might not hear everything that they thought they were going to?
Well, generally speaking, my experience is that families are relieved when someone pleads guilty, but of course that depends on the individual family members and, as you say, the stage at which that guilty plea is entered. And if a family have psyched themselves up for the prospect of sitting and listening to all of the detail for weeks or even months, and then suddenly none of that is going to happen, then I'm sure that's a deep shock and something which has to be really carefully navigated by the witness support and victim support team, which will be on hand to support the family. But every family is different. Some want to sit and listen to all the detail. Others would prefer to hear the word guilty come from the defendant's lips and a full acknowledgement of guilt. So you can't speak about any individual family because everyone's very different. But this is not an unusual scenario that someone changes their plea very late in the day.
OK, thank you very much for your insight. Daw KC, barrister, legal commentator, author of the book Justice on Trial.